Now, even though the actual hearing today wasn't exactly cinematic, it was still fairly dramatic. This case with 19 defendants all demanding different things is sort of a logistical nightmare. And the logistics really matter here. The logistics are going to play a very meaningful role in determining how and when this case gets to trial, which in turn could be critical in terms of actual accountability. Today, lawyers for Ms. Powell and Mr. Chesebro tried to argue that to meet their defendants' rights to a speedy and fair trial, that they should both be tried next month individually. The judge here, Scott McAfee, did not go for that. So their trial is still set for next month, October 23rd, but Mr. Chesebro and Ms. Powell will be tried together. The judge essentially asserted that because Powell and Chesebro have never met and because they will tell the jury that, the idea that they would have any guilt by association issues is null and void. And Judge McAfee isn't going to waste court resources trying them separately. So at the very least, Mr. Chesebro and Ms. Powell go to trial next month, which is a little over 6 weeks from now. But that brings us to the much bigger question posed today. Do the 17 other defendants, including a one Donald Trump, do they have to go to trial next month as well? Now, the prosecutors from the District Attorney Fani Willis's office, they think, yes, they should.
Judge, we contend that we must prove the entire conspiracy against each and every one charged. Each and every one charged. So the court, in the interest of judicial economy, would have to make the decision as to whether or not the court wants to try the same case 19 times or 2.
The state's position is that whether we have one trial or 19 trials, the evidence is exactly the same. The number of witnesses is the same. And so many of the arguments that are made on the other side evaporate.
Today, the prosecutors told the judge that because they believe they need to prove the entire conspiracy in each and every case, even if a trial is just for one or two defendants, each trial will take roughly the same amount of time. Prosecutors estimated that a case against all 19 co-defendants together would take 4 months, in addition to whatever time jury selection takes. And Fani Willis's office anticipates calling upwards of 150 witnesses. 150. Again, DA Willis's team says that 4-month-long 150 witness estimate is the same, whether the case is brought against all 19 defendants together or whether it's just Kenneth Chesebro and Sidney Powell. Still going to be 4 months, still going to be 150 witnesses. Now, the judge not only seemed sympathetic to that argument, but actually thought prosecutors were underestimating how long these trials would take. Judge McAfee thought a trial could easily take more like 8 months, which, though I have no law degree at all, makes sense to me. I mean, jury selection for this case feels very tricky, and 150 witnesses seems like a whole lot of witnesses. So splitting the cases, severing them from one another in the parlance of the court, and having one trial in October for just 2 defendants and then another further down the line for everyone else, that could be setting up the court for some very lengthy hearings, not to mention staggering inefficiency. But Judge McAfee appeared to be even more skeptical of the alternate option, having all 19 defendants go to trial together on October 23rd. In particular, he seemed worried about whether it was even logistically possible to get through all of the pretrial motions for 19 defendants, including, by the way, a former president, and get through all of those in just a month.
This is going to be a case with a lot of pretrial motions. And again, I don't know how many hearings we're going to need to have to sort through all those. But if we compress our timeline to 40-something days, our ability to even be able to really weigh those and think through these issues, again, it just seems a bit unrealistic to think that we can handle all 19 in 40-something days.
The judge has given DA Willis's office a deadline of next Tuesday to file a brief explaining how they think a trial for all 19 defendants starting on October 23rd could actually work. Joining me now are Christy Greenberg, former deputy chief of the criminal division at the Southern District of New York, and Mimi Rocah, former federal prosecutor and the current DA for Westchester County right here in New York State. Christy, Mimi, thank you for being here tonight. Okay, I mean, this is really where the fact that I have no law degree comes shining through in glaring light. But 19 defendants October 23rd. Are we operating in the same universe as the DA's office? Is this even possible, Mimi?
Look, I think if the DA says it's possible, which she has very affirmatively, I think it is possible. Do I think it's going to happen? Do I think it's maybe the best idea, even for the case? No. I mean, the judge will decide that, but, yes, they have to prove the conspiracy no matter how many defendants are in the case. They have to prove the enterprise. They have to prove, in essence, the same case. But having 19 lawyers to do cross-examinations, to make objections, that is what will make that size of a case much
unwieldy.
Longer and unwieldy. And I think this judge seems very common sense. And, I think the DA is doing absolutely what she should be doing. The government is always ready. The people are ready. The state of Georgia is ready. And so she is ready. Would she do it if she had to? Absolutely. And I'm sure she'd do a very good job.
Okay, but and the estimate, our eminence grise, although I'm sure he would not like the Grease part of that. But Andrew Weissman tweeted today, Fani Willis saying she will call 150 witnesses is really absurd. Overtrying a case is never a good thing for the government and opens the door to the defense to score points and play games. 150 witnesses, no matter who's on trial, it does seem aggressive, does it not?
It seems unwise to say that you are going to present the exact same case no matter who the defendants are. If you only have two defendants who are a part of two very discrete schemes, you don't need to start proving up all of the other evidence with respect to 17 other defendants that the jurors are never going to meet. That's going to be confusing, and the jurors may start to resent the prosecutors for making this go on so long. I mean, she's estimating 4 months. The judge said, actually, that could take 8 months. Again, you have to prove a pattern of racketeering. You have to prove there's an enterprise. But you don't necessarily need to put on the exact same case to do that when you only have two defendants versus 19.
Why is she doing that, then? Is that just because she wants these folks tried together? And if she does, what is a reasonable timeline for that, Mimi?
I think she's doing it, again, because I think that is the position that a prosecutor who charges 19 people together must take. You must say that you're prepared to try them together. And yes, because she believes that they acted in concert. They acted together. And so it would be more efficient in some ways, from her point of view, to do the case once. I sorry to interrupt you. I understand why she wants them to go together. I guess I'm confused as to why she says, regardless of whether they're tried together, they're all going to get 150 witnesses at their trial. Yeah, look, I think they're making arguments right now to the judge as to why he shouldn't break it up. And this is one of several arguments that were made. I've charged 40 defendant cases. They were organized crime cases. I've never had more than 4 at a time go to trial, either because most of them pled out, cooperated, or because the judge severed them. It's not common, but I do get the sense here that this judge is going to not have separate trials for everyone, but maybe break it up into some more manageable pieces. And then or wait and see, though, right? Who does plead out? Who does cooperate? I mean, it's very unlikely that all 19 will go to trial. They have a right to, and they might, but in experience, that's just unlikely to happen.
Well, right. I think the broad assumption here was that 19, a bunch of them are going to flip. They're going to plead out, whatever. When does that part start happening? Because TikTok, it's September 6th. I don't even know what day it is. October 23rd is not that far away from now. And that's the sort of expiration date we are theoretically working with. So what is happening behind the scenes with some of these defendants?
It starts now.
Okay.
There's a scheduling order now in the case with Powell and Chesbrough. And if you want to be a witness in that case and get cooperation points for the fact that you are going to testify at that trial, getting in now would make sense, and before any pretrial motions are filed. So you have to imagine at least some of these 19 defendants are having real conversations with their lawyers about whether or not they're going to cooperate.
There's another part of this that I think has gone largely under discussed, which is the removal piece. Mark Meadows and other defendants are saying, take this out of state court, send it to federal court, right? That decision has not yet been made. There is likely to be an appeals process that could take some time. This is what Judge McAfee, I think we have the sound from him today, bringing up that very important point to the prosecutors. Let us take a listen.
So if it's a 4-month trial that starts in October, we're potentially sitting at a point where we've presented the entire state's case, maybe even the jury has returned a verdict, but we can't enter that judgment of conviction until the 11th Circuit comes to a decision. Is that kind of the scenario we're playing out here?
Help me understand this, Mimi. So if, for example, Mark Meadows is still trying to appeal, let's say they say, you can't throw it out, it stays in state court. And if he appeals that decision, it's working its way through the court system, potentially at the same time that the trial is still happening. And if a verdict is returned in the trial, you cannot actually convict until the removal process is complete, that whole appeals process is complete. Is that right?
That seems to be what the judge is saying. I'm not sure that's exactly right. I mean, it wouldn't be right if Meadows' case was severed, right? Because you could still sever his case.
Right.
And so, but he would have to do that ahead of time, and he seems not necessarily inclined to do that. I think I think at some point he said something about double jeopardy, and he's worried about a conviction, at the state level, and then there's going to be a federal possible trial. There's also still the question of whether if Meadows' motion is successful, does that mean everybody's? And the law is not clear, as many people have said, on whether. So that's going to have to be decided as well. So look, I don't know. I mean, I would be hesitant to predict how this is going to play out. I don't think anybody can.
Wait, it's terra incognita, legally speaking, in a certain way, isn't it?
Yes, that is.